Okay. Good afternoon, everyone, and thank you all for joining us for today's a month of service presentation of what is Small Claims Court. My name is Nia Murray. I am the programs coordinator with Neighborhood Recovery Community Development Corporation, and we are one of the partners in the A Month of Service collaboration. Also included is the City of Houston's Department of Neighborhoods, Lone Star Legal Aid, the Earl Carl Institute, Harris Central Appraisal District, Harris County Tax Assessor Collector's Office, Houston Volunteer Lawyers, and on behalf of the Houston Bar Association, we have our presenter for today, Ms. Megan Deitch, right? Is that correct? Okay.
That was
With
perfect. Thank you.
the Deitch Law Firm, who's going to be presenting and giving you guys the information that you need today about small claims and small claims court and the processes and so on and so forth. Again, A Month of Service is a collaboration of all 8 of these different organizations that you see here. We come together on a monthly basis and offer a variety of different workshops, presentations, and information to the communities relative to asset building, asset protection, community empowerment, and the maintaining of generational wealth. So we wanted to make sure that we created a larger impact to service all the communities that we all serve and reach more people by coming together and providing this information for those underserved and underreached communities that don't necessarily know where to go for particular information or resources and what's available to them for free or at no charge. So here's your opportunity. If you have questions, please feel free to ask of the presenter. However, I do want you to keep in mind that we want to try to protect your privacy as much as we possibly can. So if you could keep your questions to be as general as you can, as well, so that way, your personal detailed information does not get out there for everybody to have access to, as we are recording this session as well as broadcasting live on our social media platform at Amos Houston TX. So again, we want to try to protect your privacy as best we can. In addition to that, the information that is presented here today is for educational purposes only. It is not to be considered legal advice. However, we do encourage you, if you find yourselves in need of any civil legal service, then we do encourage you to reach out to our legal service partners for some type of assistance. Please do not automatically discount yourself and automatically assume that you won't qualify, as the services of these legal organizations are for free and based on the income. So with that being said, I know we are on a time crunch for today, so we're going to go ahead and have Ms. Megan introduce herself, and we're going to move right on into our presentation for today.
Perfect. Thank you so much. Yes, my name is Megan Deitch, and I'm an attorney and owner of Deitch Law. And I'm going to go ahead and share my screen and start this PowerPoint presentation. Can you see the PowerPoint okay?
Yes.
Wonderful. Okay. So there we go. Okay, wonderful.
Swap
Great.
your
So today
we see your notes.
Oh, yep, I see it. There we go. Did that work?
No. Oh, now it did. Yes.
No,
Yep.
Okay, perfect. My computer's slow. I apologize. Okay, great. So so I'm an attorney and owner of my own firm. I'm also adjunct faculty at the University of Houston Law Center, where I teach things related to alternative dispute resolution. With my firm, we do a lot of things in small claims court. We're also in county and state court, but primarily small claims court, also known as Justice of the Peace Court. So today we're going to talk a little bit about these different topics. So understanding of small claims court in Texas, what types of cases are heard in this court, how do you initiate a small claims case, representation in small claims court, the process in small claims, appealing a judgment, tips for success, and then also Q&A. And so throughout this time as well, if you'd like to drop any questions in the chat, please feel free to do so. We'll get to them towards the end. Okay, so small claims court, and again, in Texas, we also call it Justice of the Peace Court, the legal venue that allows individuals to resolve disputes involving relatively small amounts of damages. The limits were actually raised in the last few years. It used to be of damages no more than $10,000. Now it has been raised to $20,000. So if you have a claim that exceeds an amount in damages of over $20,000, you would not be able to file in small claims court. So the purpose of this court is intended to provide an accessible and informal legal process for resolving disputes quickly and inexpensively. So really the advantages are that it can be cost effective because the filing fees are pretty low, which you can find on the different court websites. And in the various counties, they'll show you the filing fees. It's very informal in comparison with state and federal courts. These judges are elected into these positions, which is similar to a lot of our county and state court judicial positions as well. But they did not have to go to law school. They don't have to be practicing attorneys. They are elected into these positions. And so the Texas Rules of Evidence do not automatically apply in these courts. There are the Justice of the Peace Court rules that do apply. These all can be timely, more timely than if you were to file in a higher court. I did say in some cases, we have seen backlogs in a lot of these courts because of COVID, but some move really quickly. I've got some cases in different counties where they're moving their cases within 30 to 90 days. Others, 6 months, I would say is probably a good average between when you initiate the lawsuit and when you have trial. Others can be much longer. It just kind of depends on how each judge is running their court. And the types of cases that you could hear in small claims include eviction and landlord-tenant disputes. So eviction, I'm sure you're familiar with, and that can be for back payment of rent or other reasons for eviction. And then other landlord-tenant disputes. So for instance, if you had a repair and remedy dispute against your landlord, you could file in small claims. Breach of contract for goods or services. This is pretty much what we see with these debt lawsuits. So credit card debt, personal loans, student loans, if you had a vehicle installment agreement, so a loan on a vehicle, insurance subrogation. You may even be sued here if you did get into an accident, if the motor vehicle accident was your fault and you did not have insurance coverage. It is possible that the other driver's insurance company could sue you in this court, or again, a higher court as well, but we do tend to see a lot of these in small claims court. You also may see some personal injury claims, not very many, just because the damages a lot of the time do tend to exceed $20,000, but it really does depend. Various small loan disputes. So sometimes we see that where it may be individuals. So you loan a friend some money, they failed to pay you back. You could bring a claim in small claims court. And again, similar to that, claims against other parties. Sometimes you'll see claims against neighbors for issues related to the neighbor or lack of neighborly relationship. So again, various claims in this court, as long as your damages do not exceed $20,000. So how do you start a small claims case? So in order to initiate one, you start by filing a petition with the appropriate small claims court. So typically what would happen is you could actually go usually to a county website, and like in Harris County, for instance, they offer a lot of free online resources, and they do have different copies of petitions that you could file with the court. You would then have to pay a filing fee as well. In order to determine the appropriate court that you should file in, whether let's say it's precinct 4, place 1 or precinct 7, place 2, you usually are going to look at either where the defendant resides or maybe where the actions leading rise to the claim occurred. Then you would pay the filing fee. And so they do have that listed usually on the county court's website. And you would see it specifically for Harris Justice of the Peace Courts in Harris County. They've got those prices listed. And then you do have to serve notice to the defendant or multiple defendants if there are more than one. Usually you can pay an additional fee in order to use, let's say, like somebody from the sheriff's office. But there is a fee associated with having somebody served as well. Usually that form of service, what happens is they're serving a copy of the petition as well as a citation. That's a formal legal document provided by the court that allows for service. Those documents usually at first are attempted to be served on the other party in person. Eventually, if the process server is unable to effectuate service, then you may be able to request an alternative form of service, such as leaving it at somebody's door or possibly even mailing it via certified mail. But you do have to try to serve them in person first. And then you would need to prepare for the hearing or trial setting. Usually you would receive notices from the court indicating whether or not there are any upcoming hearings or trials. If you do move, make sure to update your address with the court. We see that happen a lot, especially in debt lawsuits, because that's primarily what we do. People typically don't end up or forget to update their address with, let's say, a credit card company. So then they're later served via an alternative form of service at an old address that they may no longer live at. So it's just important to kind of keep your address updated. That way you can get the important legal documents from the court. And then in representing yourself in small claims court, you definitely can. I mean, this is known as the People's Court. There is opportunity for this, but please just know that there are various legal resources out there. In addition to, let's say, legal aid services that are provided, there are firms like mine where we do represent individuals who've been sued in small claims court, usually either for reduced fees or, low payment plans. So my clients, some of them pay as little as maybe $50 a month for our services. So just know that you're not alone if you are looking for or need representation. But if you are wanting to represent yourself in small claims court, just evaluate the options of representing yourself. It's considered pro se. That means that you're representing yourself. And again, consider that versus maybe possibly hiring an attorney. You would then want to learn the rules and the procedures of the court. So let's say you are in Fort Bend County and you have a case in Fort Bend, Justice of the Peace Precinct 1, Place 2. A great place to start would be to Google that court, go to their website and see what that judge's rules and procedures are so that you're familiar with the process. And then leading up to any hearings or trial or even mediation, you would want to prepare and organize your evidence, and that's the state and documents. So legal mechanisms in small claims court. So like I mentioned earlier, the Texas Rules of Evidence do not automatically apply in Justice of the Peace Court. What this means is if you watch any legal shows where they say, objection, Your Honor, hearsay, or objection, relevance, things similar to that, the rules of evidence are applying. In Justice of the Peace Court, those rules do not automatically apply. Myself as an attorney, I have a motion that I file and I set it for a hearing to try to apply the rules of evidence. I like the rules of evidence to apply because I do know them and I know how to work within those confines and additionally get discovery or evidence from the other party in advance of trial. So the JP courts, they have their own rules. So if you were to do a search for Justice of the Peace Court rules, they're in the 500s. So that's the rule. It's like JP Rule 500, I think to like 510 or 520. They've changed over the years. So that's really what's going to be prevailing. And that walks you through things such as, how to file a claim, service, how to perfect service, how long does the defendant have to respond to a lawsuit. I will tell you in Justice of the Peace Court, you have 14 days from the day that you've been served. And that is not 14 business days, that is 14 calendar days. One thing that we do is we file something called a motion to conduct discovery. If we would like to see the evidence in advance of trial, which we usually would like to see the evidence prior to trial, we will file a motion to conduct discovery to request those documents beforehand. It's entirely up to the judge whether or not they're willing to grant it. And sometimes they'll grant it, but they'll just limit it because again, this is a people's court and they really don't want to do anything that makes the process more timely or kind of frustrates the process. So they want to keep it as easy as possible. But again, there are some situations where it'd be really helpful to know in advance, what the other party is actually claiming. For instance, if you are being sued for a rental agreement and a landlord or a former landlord is claiming that you owe back due rent or there's a breach of contract because you moved out early. If you're unfamiliar with the terms of the agreement, you may want to be able to conduct some discovery so that you can request a copy of the lease agreement from the landlord because it's likely that they have a copy even if you do not. There's some things also that typically need to be called verified. I won't get into this too much just because this is really a formal legal mechanism, but there are some arguments or some defenses rather that you would need to make that would need to be verified. So you would actually need to have like an affidavit that's notarized. So for instance, one of the most common things for us is there are a lot of third-party debt buyers in the state of Texas. That means that let's say you had a debt with Synchrony Bank and that debt was bought by a third-party debt buyer. That third-party debt buyer likely does have a right to sue in the state of Texas. Third-party debt buyers typically have to get a bond through the Secretary of State in order to try and recover. And they essentially step into the shoes as the original creditor, in this case, Synchrony Bank. If we were going to try and argue that they are not the proper party to bring the claim, then we may want to file a verified denial because that is something that requires a verification. And the other big thing too is, mediation, of course, which we'll talk about more later on, and trial. So typically you're going to have a couple of options in front of a judge, which would be a bench trial where you can present your evidence, or you can request a jury trial. Usually a jury trial, it needs to be requested at a minimum, I think 14 days before trial, and you do have to pay a jury fee. Usually I think in Justice of the Peace Court, it's around $21 or so, but you would just need to check to see what those fees are. That would allow you the opportunity to have a trial in front of, a panel of your peers. The thing about that is you do, of course, have to know how to pick the panel to get them on the jury, how to present your evidence, make sure that it gets admitted. So if you're considering a jury trial, you may want to talk to an attorney. Bench trial may be a bit easier because the judge will be there. The judge cannot provide you with legal advice, but they will let you know, for instance, at this time, please present your evidence. So they should make that a little bit clearer for you. Okay, so after you file the case and sometime before trial, there is a chance that you may have a pretrial conference or mediation. A lot of judges will schedule a pretrial conference because they want to see the parties. They want to know if the parties have met, if they've spoken to each other yet, and if there's been any attempt to try and resolve the dispute. At the pretrial conference, the judge may also consider other things, such as if there's discovery that needs to be conducted, or if the parties, let's say, need to mediate. It depends on the court. Sometimes they will have you mediate that same day. Other times, they'll ask you to mediate later. Other times, they'll force you to mediate before trial. So it just kind of depends on the judge, on the court. In Harris County, we do have the Dispute Resolution Center, also known as the Harris County DRC. You can actually mediate claims there for free. There are volunteer mediators. So mediation involves a third party neutral. This is someone who does not represent either of the parties or any of the parties involved if there are more than two parties. And what this neutral third party individual tries to do is they basically get the information from both sides. In small claims court, typically you will have a joint session. So the parties will start off together, and you may even be together in the same room the entire time. If needed, you can request to separate though, and sometimes they can accommodate that, sometimes they can't. Post-COVID, we also see some courts going back in person, some are still online or virtual. You may have an opportunity to either mediate in person or possibly virtually. I believe the Harris County DRC is still doing mediations virtually. So that makes it a little bit easier and more time efficient for you as well. So again, something to look at if you were wanting to mediate with the DRC. And again, that mediator's role is not to pass any sort of judgment. It's really to get the information and serve as a facilitator between the parties to try and see if a resolution can be reached. Their goal is to help you try and reach a resolution, but that is not mandatory. If you do not reach an agreement, if you do not settle at mediation, that's okay. And everything that is discussed at mediation is confidential. So then after, let's say you have a mediation, let's say it's not successful and you say, okay, we're moving on to trial. Then you would have the hearing and presentation of your evidence at trial. Again, either a bench trial, which would be in front of a judge, or a jury trial where you've requested a jury, you paid the jury fee, and they're going to be bringing in a jury. If you do request a jury, it may take longer before you actually have your day in court, just because it may be more difficult for them and costs money and is a little bit more time consuming for the court to be able to bring in some panelists to get a jury. So just something to keep in mind. Also keeping in mind that a jury, may not fully understand the law. They may not fully understand the facts. A judge, they do see most of these cases, on a day-to-day basis. They unfortunately have lots of cases, way too many cases probably in their court. And so they're pretty familiar, with these sorts of cases that are brought in small claims. So let's say, trials proceeded and there's a judgment, meaning let's say the plaintiff has filed a lawsuit for $10,000 in damages for a loan that they paid to a friend. And a judge or a jury determines that that defendant friend does owe that $10,000. Of course, there's always opportunities to try to reach an agreement if you're willing to do that amicably. But once you have that judgment, then the next step is enforcement. So there are different resources on, let's say, the court and county website, as well as Texas Law Help Organization website. So there are tools and resources there that can help you try and figure out how would you actually enforce a judgment. Some of those options include things like maybe garnishing a bank account. Okay, so what happens with the judgment? And so what does it mean? Again, if you were to go to court and you were to get a judgment rendered against you, meaning let's say that Synchrony Bank debt that we talked about earlier, Synchrony Bank has sued you, you've gone to trial, and a judge or a jury has determined that you owe Synchrony Bank $3,500. What does it mean once there's a judgment? Again, you do have the opportunity to try and reach an agreement with the creditor. It's usually easier and more cost effective for them to reach an agreement with you, even if that's on a payment plan. Sometimes what may happen is, let's say a party either doesn't want to proceed with the lawsuit, or they don't have all of the necessary evidence that they would need to present at trial. They can non-suit the case. So there are two different kinds of non-suit. One is with prejudice, meaning that they cannot refile again in the future. That usually only happens if you resolve a dispute and pay the full amount that's been agreed upon and it's been paid prior to trial. That's usually when you would see that. And there's a non-suit without prejudice. Without prejudice means that they do reserve the right to refile again in the future. So as long as they file within the applicable statute of limitations, they reserve that right to try and refile. And then usually with a judgment, all depends, again, if the other party, let's say, had an attorney, but some additional things that they can request, parts of their rights and remedies include interest, court costs, and attorney's fees. Something to keep in mind, though, I know I mentioned that the jurisdictional limit of the Justice of the Peace Court is $20,000. So let's say you have an attorney and you are claiming damages of $20,000 plus attorney's fees. If those attorney's fees would push you over the $20,000 mark, then you likely should not be filing in Justice of the Peace Court and would need to file in a higher court like county court. So they can actually dismiss your case to have it moved to a different court. So some other options, if you have received a judgment against you, or let's say you were the plaintiff, so the party bringing the lawsuit, and you lost, at your day in court, you do have the right to appeal. So there is something called a waiver. So it's an affidavit of necessity, where basically it asks you a series of questions. I think now the affidavit's like 7 pages. It asks about your income and your expenses, if you receive any form of governmental aid, and what sort of financial circumstances you have that should qualify you for a waiver of the appeal bond fee. Because typically, if you want to appeal a decision made in a lower court, you have that option, and you can automatically appeal it to county court. But you would have to pay the bond, and that bond is usually either 2 or 3 times whatever the judgment amount is. So just something to keep in mind, if you do qualify for financial necessity, then you could file this sort of appeal bond waiver. It is, at least in Harris County, they have it on the court website. You fill it out, you get it notarized, you send it to the court, and then it gets appealed to a higher court. Okay, so for some tips for success in small claims court. Again, if possible, speak with an attorney. There are various even law schools. I know University of Houston has a consumer law clinic. There are different clinics that you may even be able to get a consultation with, at least to point you in the right direction. If you don't end up hiring an attorney, no harm, no foul, so at least you know you're going in the right direction. You can also chat with a legal aid resource, which I know we heard of multiple ones, at least 6 mentioned earlier today, that provide you with these opportunities to get some guidance and resources. You also want to gather all of your evidence and documentation and make sure to keep it in a safe and secure place. So let's say you are wanting to sue for a lack of repairs to a vehicle, and you're suing an auto repair shop and saying you didn't fix my vehicle or you further damaged my vehicle. You would want to make sure that you have your proof of receipts, payments, photos of the damage, anything that kind of relates to the claim, make sure to have that with you. Also important, to be organized and to be prepared. So it's really important once you end up in your day in court to understand that this is a court of law and there will be a judge, there will be other parties present, and there will be other individuals present because they will have cases either before or after you, because these courts do get rather busy. So it's really important to be organized and be prepared so that you're using your time as effectively as possible. The judge will want to make sure that you can prove your claim, or that you have your evidence suggesting that you don't owe, let's say, this debt that the other party is claiming. And make sure to listen to the judge, be courteous, and be respectful to everybody. So I know a lot of these situations can become very, very emotional and heart-wrenching. And so you do deserve your opportunity to speak to the court. But it's also important to be mindful of the fact that this is a court of law. And so a judge also has to adhere to various rules. And so they want to make sure that everybody's listening to each other party. It's always good to get information from the other side. It's just more information and knowledge for you, and to not interrupt one another, and especially not to interrupt the judge. You also want to make sure to dress appropriately for court. This will look different for everybody. And again, I mentioned earlier that this is more of an informal court. But, I would say maybe like Sunday best, making sure ideally that you're wearing maybe some kind of closed-toed shoes, bring a jacket. It can get cold in these courtrooms. And that, you're dressed appropriately for a court hearing. Just make sure you're putting your best foot forward. The judge will, of course, take all of those things into consideration. You want to be respectful and as concise as you possibly can be during the hearing. Some of these hearings you'll see, we see it all the time, especially with these debt lawsuits where you have, sorry, I keep moving that, creditors who are presenting their evidence on a debt and the defendant doesn't appear. Those can take less than 2 minutes for them to present all of their evidence and get a judgment against somebody. We've seen it happen in less than 1 minute before. So they are clearly being very concise and presenting the evidence all at once. So again, not that you don't deserve the right to be heard, definitely share your side of the story, but make sure to practice it beforehand. Maybe talk with some friends, family members about the situation, and ask them for any feedback that they may have. Part of this is storytelling, and how to organize a story so that it's persuasive and makes the most sense for you and for what remedies you're looking for. And just so you're aware too, you can always reach out to the opposing party before trial to try to reach an agreement. If you have an attorney, your attorneys will likely already be corresponding with one another prior to trial, and will discuss any issues that come up with the case. If you're representing yourself pro se, so representing yourself on your own behalf, and if the other party is as well, you could reach out to the other party and see, if resolution is an option. If not, you always have the option to try to go to mediation, and that third party neutral could help the parties try to reach some sort of an agreement. And I mentioned that there, you can request mediation with the Dispute Resolution Center. I know I mentioned Harris County is free. Most or many counties throughout the state of Texas have their own DRCs or Dispute Resolution Center, but they do have differing fees. Harris County is free, whereas I think Montgomery County charges a fee. I think Fort Bend County has a fee. They're pretty limited in the fees, but I think it could range anywhere from maybe $50 to $75, could be more. So just something to look into. So in conclusion, small claims court is the people's court. It is meant for you, for the people. And again, this is where you can bring different types of claims. You can represent yourself either as the plaintiff or as a defendant. Always a great idea though to get legal advice if you possibly can. So just something to keep in mind. And there are various opportunities along the way to try and reach a resolution, or at least to gather more information that can help bolster or strengthen your case when you have your day in court, either in front of a judge or in front of a jury. So at this point in time, I'm going to stop the share, and I figured I would open it up for questions if anybody has any questions.
We don't have any that are in the chat, but there was one that was emailed to me prior to. Let me get the exact verbiage here. It says, I just had it. I just had it. Okay, when a neighbor clearly encroaches onto your fence, what is the best way to properly resolve this issue?
That's a great question. And when I was coming up with the neighbor issue, that's kind of what I was thinking of that happens. I will let you know, so I am not a real estate attorney, not that you necessarily need one for this, but given the fact that I focus a lot on alternative dispute resolution, I do try to remind people that the first step, of course, is not to escalate, right? Because this is your neighbor. So unless you're okay down the road with moving and saying, I'm okay with going off on this neighbor and doing whatever I want, they're likely going to have to be your neighbor for a long time. So I always think about the relationship. What can we do to resolve this and to fix or mend this relationship? There are different, like more legal and non-legal options. So of course, trying to have a discussion with your neighbor. A lot of the time, this kind of comes down to maybe either miscommunication or a lack of understanding the interests of the other side. Again, maybe they think that this is their property line and they've just been misinformed, and maybe a conversation can help that. In some instances, I have been hired or at least consulted with by people before who said, well, could you send a demand letter to my neighbor? Like, I want them to stop doing this or stop doing that. Usually my assessment is I could always recommend it. Or I could do that for somebody, but I'd like to know first, like, what attempts have been made beforehand, because again, once you get an attorney involved, that kind of escalates things. It may be helpful if things have already been escalated and you need people to jump in to sort of, ease that tension. There's also, of course, the DRC. You could always mediate with the DRC. I think that's helpful. And then, of course, you would probably want to look to see if you have like an HOA or any deed restrictions. Look at any documents you have regarding, like I said, maybe property lines. So I think those are some options that you would want to take first before trying to file a claim.
Hey, Nia.
Yeah.
I would first call 311 and call in your concern to the City of Houston Department of Neighborhoods or to the Public Works Inspection Department, and let them go out there and confirm your concerns and let them handle it from there. And if the City of Houston can't handle it from that point, then go further. But I would first call 311 and call in your concern and let the City of Houston assist you with your concerns. Thanks, everyone.
Okay. So what if
Sounds
someone's
great.
outside of the
Thank you.
city, Myra, then which jurisdiction or who would they call then?
Call the county, whatever county they're in. They also have different organizations, just like Department of Neighborhoods. Also, they also have inspections. We live outside of the county. When we were building our house, we had to go through the county through that process. So each county has their own inspections and process.
Okay. Another question here. Can you bring a claim against a contractor or subcontractor and manufacturer of a failed product?
So usually when I see the term contractor and subcontractor, I see it more in terms of, let's say, construction. But if you're looking for like a manufacturer defect, if that's what you're looking for, you can. But again, you need to consider what your damages are. So for instance, if you had like a faulty hair dryer that exploded, your damages may exceed $20,000. So, and that would be looking at like medical bills, mental anguish, any sort of like loss of income, and you need to look at both past and future. So in that situation, I would, try and consult with an attorney. You may be able to find a personal injury attorney to assist you with that. And usually they will work on a contingency fee basis, meaning that you don't have to pay upfront or out of pocket. But if it is something that falls within those jurisdictional limits, you should be able to. You could try to file it. Again, it kind of depends though where the defendant is. If it's a national organization or a company, that kind of comes down to what's the proper jurisdiction for it. And so if they are not based in Texas and in this county, smaller companies maybe so. Larger companies, like if you tried to sue Volvo in small claims court, you have some difficulty because that would probably need to get removed to federal court.
Okay. Another question here, something similar related to a contractor. If I file a claim against a contractor, how is the person forced to pay me the money that is owed? In other words, how does the enforcement part work in terms of actual monies owed to make sure that I am paid?
So that's sort of the tricky part, like where I mentioned enforcement. So let's say you go to court and you win. So a judge has said, I'm awarding you a judgment in the amount of, let's say, $10,000. So now you have this judgment. What I see happens a lot of the time when you have pro se plaintiffs is they don't know what to do with the judgment. They just assume that something is magically happening with this judgment. It does not. The court may have some, rules and procedures online for how to then enforce the judgment. But I mean, the most common thing we see as far as enforcement is garnishment. So in Texas, we can't garnish wages, or no one can garnish your wages, but you can garnish bank accounts. So you would then have to identify a bank account associated with that party that you have a judgment against. And then probably file for a writ of garnishment. You can abstract, you can file liens. So there are these different options and mechanisms that even I don't really like to mess with myself. But I'm usually defending people who are being sued, right? So it ends up where they come to me and they say, oh, a receiver, froze my account, or they're trying to sell off my assets. So I would really probably speak with an attorney at that time just to discuss enforcement. But again, some of the courts do have some information online that they provide regarding enforcement and forms that you can file with the court to try to enforce it.
So when you file or you're being sued and then the judgment is against you, is that the judgment that shows up on the credit report when somebody's being sued in small claims court, even, or just anything like?
So typically, I think it would kind of depend. So let's say if it's a credit card debt, that's already going to be on your credit report.
Mm-hmm.
So you will see that already. Typically, if there's a judgment, an agreed judgment, a dismissal, you're not really going to see like judgment indicated on the credit report. I think sometimes it does. It depends on how the creditor's reporting it. But if you are doing it pro se and you get a judgment against somebody, if you were trying to get it to show up on their credit report, you would have to report it to the credit bureaus. Nothing automatically gets reported like from a court.
Okay. Let's see. Also, can you bring a claim against a contractor who has since changed the company but is doing the same thing?
That's a great question.
I think this
So,
kind of goes with my
well,
question that I asked last week about when somebody files
mhm,
bankruptcy and then they turn around and they open the same business doing the exact same thing that they did before. So how does that work?
exactly. Yeah, it does go to that question. So, which I thought I had a lot more time to think about, and it became way more relevant to me in the last week, of course, as so happens when these things come up. And so the answer is kind of yes and no. So if you were to file against this new company, then there's a good chance they'll claim, well, but we're not the same company as previously. I think you'd probably want, I would need to think about this more, and this would be actual, like, you would need legal advice from an attorney on this, as to whether or not you would maybe want to include a fraud allegation to try to basically claim, look, this is the same exact company. They've got all of the same assets. They are really just doing this in order to avoid any sort of claim, for work that they've done previously. You may be able to bring it after a bad factor as well, or actor rather, not factor, such as the individual, right? If you think that this is kind of what they're doing, and which we see sometimes, closing a business, opening a new business, closing a business, opening a new business, you may be able to do it that way, go after the individual as well.
What are the range of fees for filing in JP Court in Harris County?
Let me see. I would need to pull that up again. JP Court. It's funny. JP Court fees, Texas. I think that it may be anywhere from like 30 to 60 some odd dollars, and that doesn't also include the fee for the process server though. But I'm going to pull up. They actually have the fee schedule online. It's much higher if it's in county or district court. You're usually looking at over $200 to file there.
So less than $200.
Okay. Oh yes, definitely. Yeah, it looks like maybe because I think sometimes they may have like more than one fee, like local government fee and some other fee. So I would say, but yeah, maybe between like 20 and 50 or $60 or so.
For each fee, or is that total?
So total, but probably excluding the process server fees. And it's funny, I actually had this up last week and I was like, oh, I'll be able to find this again easily. So I'll keep searching as well, but I know it's online.
Okay. Question here. Can you use small claims court to bring a claim from temporary orders from a divorce, which has been finalized for payment that were not settled, which parties was supposed to pay?
So that's a good question. Let me see. Yeah, can you use small claims court to bring a claim from temporary orders from a divorce that were settled, which other party was supposed to pay? Truthfully, you would really need to speak to a family law attorney about that. I'm not positive. I mean, family courts tend to be very different. I would think that this is something that would need to be brought up in that family law court where the divorce was finalized. I don't really see much of anything family law related in small claims court. Doesn't mean it's not possible. I know one thing that I've told people before is sometimes they'll say, hey, my ex-spouse and I didn't discuss divvying up our debt. And this is a debt that they really incurred, but I have better credit. So they took it out, or we took it out in my name. And our divorce decree doesn't really explicitly, delineate who's supposed to be paying this. Do I have any options? And yeah, sometimes you may have the option to go after them, and you could bring that in small claims court, but that's very different, I think, from temporary orders. So unfortunately, I would have to say you'd probably want to speak with the family law attorney, and my guess is that needs to be in family law court.
Does JP Courts in Houston have a writ of garnishment form that can be filed?
I'm not sure. I know that they have some forms online. I'm just not familiar with every form that the court does provide, but they do provide various resources online. Also, just so you know, I did find, okay, and I don't know when this was updated though, but it looks like Harris County Justice Court, small claims cases, court costs and service fees. Small claims court cost $15, service fee $65, so total being $80.
Okay.
And then there's a writ of execution. So there's an abstract of a judgment. These are enforcement options. It's abstracting the judgment and then a writ of execution. That's one is $5, one is essentially 80. So, but again, that also goes into a little bit more like very specific legal advice.
The page that you're on right now, can you copy that link and drop it in the chat? So that way people can
Yeah.
actually go to it. And I'll make sure that I get it included in the email that I send out to everybody as well.
Perfect. Perfect.
Okay.
And I was going to
Oh.
go through just some of the other questions that I saw as well. Okay, can you go after a contractor's small business insurance? So my recommendation would be, let's say you have a claim against somebody, find out first if you think that there is an insurance policy that could be in place, because before you go through trying to sue them, you may be able to get in contact with their insurance carrier, and the insurance carrier may have a duty to defend that other party. They may resolve it with you without even having to go in court. The alternative side of that is sort of similar to auto accidents. So if you're involved in an auto accident and there's, let's say another party hit you and you end up hiring a personal injury attorney, you're going after them because you have property damage and a medical claim, you know, for medical expenses. What will happen is you would file suit against that other party. That other party, they'll likely have auto insurance. So what happens is if you're current, you know, on your auto insurance payments, they have a duty to defend you. So that defendant that you sued, their auto insurance should step up and they should actually provide representation. Similarly with business insurance, if there is a business insurance policy that could cover the claim, they should have a duty to step up and either provide representation, maybe settle the claim, or at least try and resolve the claim.
Okay. Can you file a claim in JP court for someone that violates the Fair Debt Collection Practices Act, either state or federal?
That's a good question, because I don't do any of these anymore. If you're doing it federal, no, then you would actually have to file in federal court. I'm pretty certain most of these too, you do have to file in state court. So I think it's either state or federal.
And don't they generally have their own separate like departments? I know with the Fair Credit Act, it's the Consumer Financial Protection Bureau. You'd actually have to contact them and fill out the form and all of this, file the claim or submit the violation or whatever it is through all of their channels. They have a whole process of what you have to do for that.
Yeah, and because I don't handle those, it's possible that you have to do that first. I know with some claims that you bring, like some federal claims, you have to exhaust all of your administrative remedies first before you file. So that's very likely.
Okay.
The next question I know relates to child support and ramifications. So again, I'm not a family law attorney, so I would have to defer probably to a family law attorney there. I do know that the state of Texas takes child support very seriously. Most of child support, all of that is taken care of, I think, through the Attorney General's office. So I would reach out to a family law attorney or the AG's office as well.
And for the person that did ask that question, I'm not going to call your name, but if you want to send me an email, I'll send you the link for the divorce and the child support workshops that we did with an attorney earlier this year, so that you can kind of get a little bit more information about that. Because I know that they did go into details about, you know, what to do if somebody doesn't pay and things. So that could probably answer your question. So definitely reach out and I'll send you that link. Okay, so I see where you put let's see. Can you use small claims court against your apartment complex for example, didn't get the renewal notice for signing the lease, and when I was, let's see, and when I asked, they said it's a courtesy and that my rental increase was double. Apartment associations that it says that it's not true, and I could file a small claims I could file in small claims court. You basically have to look to see what your lease actually says about renewal. Generally, they have generally they have to give you a 30-day notice, but 60 days is a courtesy, but 30 days is generally the kind of the rule. But you will definitely have to look to see what your lease actually says.
That's what I was going to say. Yeah, it just depends on the lease terms. There are things that fall under the real property code as well, but most things can kind of, not everything with real property code, but there are certain things that can be kind of contracted around. So it kind of depends on, on the lease agreement.
Yeah, and then FYI for that, there is no law about how much or what's the max that they can raise your rent like from after your lease is over. So they could double it or
Right.
triple it from year to year, and there's no limit there. Okay. I believe those were all of the questions that were in the chat. However, I did have another question as well, real quick, because I know that you've got to go. If someone realizes that they're in a dispute or they have this case for small claims and someone has an attorney and they don't, is it recommended they actually get an attorney themselves, or is it still okay for them to represent themselves in court?
It's still okay to represent yourself in court. I will let you know, usually because again, I'm representing usually the defendant, so they're the debtor. When we're going up against a pro se plaintiff, like this is just rule of thumb, we tend to win a lot more. So when the other party is not represented by counsel, we're still be able to do things such as get motion to conduct discovery done or granted by the court. We then serve it, they don't respond to it, they then can't present evidence at trial. So, I mean, they're kind of, like I said, these legal mechanisms that it can make it a little bit trickier if the other side does have an attorney. That being said, if you're willing to have discussions with the other side, and if they do have an attorney, you could always call the attorney, and just see how amicable you think things are going to be, and then kind of make a decision based on that conversation.
Okay. All righty. I believe those are all the questions that were in the chat, and I don't see any that are on Facebook. All right, so I know you are on a very tight time schedule for today, so I don't want to hold you too much longer. If we wanted to reach out, how can we? Megan, with your contact information.
Yeah, I was going to check with you first, see if it was okay. I'll drop my office number, which I get notified of everything that comes through, as well as my email address down here. And again, what I primarily do, this is why we're in, small claims court all the time, is debt defense. So I was in the Houston Chronicle last year. There was a reporter who, she did some great pieces. I think there were maybe 3 or 4 on what happens with these debt lawsuits. I mean, these law firms that represent creditors are filing tens of thousands of debt lawsuits each month. And it's something like over 80% of people don't even respond. And so they get these judgments against them. Unfortunately, one thing I didn't mention earlier is that a judgment lasts for up to at least 10 years. So if someone gets a judgment against you, and let's say they also got interest that can accrue on it, and let's say post-judgment interest is 8%. This year's 2023, they could try and enforce that judgment up to another 10 years at a minimum. And if it's accruing 8% interest that whole time, that obviously just increases astronomically. So I always recommend, hey, try to get it resolved sooner rather than later if you can. There are also other things to consider too, like in these debt cases, we also get some financial hardship reviews that can either help us to maybe work to settle a case on like $25 a month, or possibly get a matter dismissed. One interesting thing with these debt cases though, is let's say you have a debt that's $10,000 and you're able to resolve it for $5,000. That's great. You got this 50% reduction, which does happen a lot of the time actually. There are tax consequences though, just something to know. So basically that other 50% that you saved can be taxed through a 1099. Yeah, I think it's a 1099-C and it gets taxed as income. So just something to keep in mind. You still wouldn't end up paying as much, but it is very shocking for people if they do receive that 1099-C.
And also, as far as the judgments, when you get those judgments on your, that show up on your credit report, just know that if like you're in the process of buying a house and things like that, you cannot get a loan without having that judgment satisfied before you even proceed. So
Mhm.
definitely something that you don't want to
Yeah,
have. And also you want to make sure that you're looking at your credit report to make sure, or to see if these judgments pop up on your credit report, because sometimes they're reported and you don't necessarily even know that they're actually even there. So please keep that in mind as
exactly.
well.
And you know what?
Um,
A
Also
lot
good
of
to
those,
check any,
I'm not, go
sorry,
ahead,
go ahead.
go ahead.
Well, I was just going to say it's also good to check. I mean, I know through COVID you could check your credit report, I think, as many times as you wanted for free. I know at least now it's one time, you know, that's free per year. You should really utilize that because we see it. It's not a majority of our cases. I would say it's less than 10%, but there is definitely fraud and identity theft. And so you really just kind of need to keep an eye on it because you just don't always know. Same thing too, even with if you have credit cards. I've had a lot of clients before who they're like, oh man, I didn't remember this at all. Or like, why are they saying that this is my debt? Well, they've been making payments on it. They're like, oh, well, I just got signed up for automatic payments. I didn't realize I hadn't been checking the statements. And unfortunately, unless you dispute it in writing, the law basically assumes that you have seen the statements, you didn't dispute it, and you owe it. So just good to really check in on those things. I know it can be stressful. Dealing with finances is always stressful, unfortunately.
and
It
we're going
doesn't
to
have
get
to
into
be.
a lot more detail next month when we do our debt collection presentation. So you definitely want to
You know what,
come.
Nia, and I was always thinking, when you're moving from an apartment to apartment to an apartment to an apartment, and a lot of people don't realize that those apartment debts will also go on your credit. So make sure you
Mhm.
keep up with your apartment lease and negotiate that also.
Mhm.
For the
Oh,
person that
also
just,
one thing I was going to say too, something that I see happen a lot of the time, if you are a really nice friend and you're like, I really want to co-sign on this loan for a friend of mine or for my grandchild or my daughter, just be really careful when you do that. I see it a lot, especially with friendships, more so than family relationships. I mean, lots of grandparents who are co-signing on cars for grandkids who then don't ever get a job, and then the grandparents are stuck with it. But if you co-sign, a lot of people have this misconception that you are not legally responsible for it for some reason, and you are. So, and they don't care how they get paid. So if you're the only one who has money, if you're the only one they can find, they will go after you. So just something to
Amen.
keep in mind.
absolutely,
Thank you all
absolutely.
so much. And I'm so sorry
For,
for rushing out early today. I just have back-to-back depositions. I apologize.
well, thank you so much. We're going to go ahead and have you go, but I did want to say for the gentleman that just asked about the fair debt attorney, I would recommend you contacting the Houston Lawyer Referral Service. It's a sub through the Houston Bar Association, and they have vetted attorneys that they actually do refer to people. So if you want a specific area of law that you're looking for, then that will be a good start for you to reach out to them and have them refer someone to you. All right, Megan, thank you very much. We definitely appreciate you taking the time out, even squeezing us in between depositions. We really appreciate that. We really would not be able to
Thank
present
you.
these workshops without the dedication of our of these volunteer professionals that come in here and actually do this. So we know we interrupted one of your billable hours, but we appreciate it.
Thank you so much. Y'all have a good day.
You too.
Thank you
Thank
very much.
you.
All right, so for those of you guys that are still here, again, we would typically have a 2-hour presentation or have more time for question and answer. I will be sending out her contact information along with this recording for you guys to go back and get the information, because I know a couple of you guys just joined and you missed the beginning part, so that you can go back and actually see it and then share it with someone else that may also find the information to be beneficial, as well as if you're interested in reaching out to Ms. Diaz, that you could be able to do that as well. So, but for those that may not income or that potentially could income qualify, we do encourage you to reach out to legal service organizations that actually do offer free civil legal services for free, as well as to the Houston Lawyer Referral Service if there is a particular type of attorney that that you guys are interested in reaching, specifically like for the gentleman that just asked. So yeah, I don't have any questions, any other questions that are on the Facebook, Myra. Was there anything else that you wanted to add or wanted to
No.
include?
What other programs do we have this week? I don't have
This
to
week we
get-
have our inheritance property, talking about clearing title and deferred property taxes and probate concerns. That's tomorrow. No, that's Thursday. I'm sorry, that's not tomorrow, that's Thursday. Next month, Ms. DH, the first Tuesday of next month, she's going to be presenting on debt collections and what the rights are for the citizens as it relates to debt collection. Let's see, we have our first time homebuyer education class that's scheduled on Saturday from 9 to 3 p.m. And then next week, we've got our evictions. Yeah, and then our will clinic that we've got that's coming up for next week. So I will be sending out the October schedule for everyone to get more information about if you're interested in signing up for any of our future classes. We are also in the process of trying to schedule and start to plan and figure out what we're going to be offering for next year. So if there are some topics of conversation or more information that you guys are needing, or if you guys may be aware of something that's going on in your particular neighborhood that you want to have somebody address for you, then please feel free to reach out to us and let us know so that we can kind of start to keep that in mind when we are scheduling. So with that being
And Nia, we're going to be having coffee and conversation on October 24th. And Ms. Lisa Nelson from TSU Oracle Institute will be discussing transfer on death deed and why it's important for you when you're starting your estate plan that you should start with a transfer on death deed. Is an easy process of protecting your generational wealth, your property, as well as creating a transfer on death deed for your vehicle with the Texas Department of Transportation. So that'll be October 24th, and we will be at A-Leaf Community Center. And if you're interested in attending virtually, as always, make sure to register at NRCDC. Go to the class, correct? Class section, Nia?
Yep. Take a class,
And
yep.
it's on October 24th. Also, if you're interested in getting pre-assessed by our four legal partners.
Service.
Sorry, my brain is not working today. It's the Puerto Rican and English kind of got stuck there. But if you're interested in getting pre-assessed with our four legal partners, that's Lone Star Legal Aid, Houston Volunteer Lawyers, TSU Oracle Institute, Harris County Area Agency on Aging, Harris County Area Agency on Aging, as well as if you don't income qualify, we're also referring you to the Houston Lawyer Referral Service. So don't forget, I know all of y'all know the link, but if you're looking for the link, go to Amos Houston on Facebook, and we will have the link as well as the posting. And Nia, will you add the pre-assessment sheet on there also?
Yep.
And the link? Thank you. Because the easier process, if you can get started at least with the transfer on death deed, which only costs you $34 to protect your property, as well as a transfer on death deed with your vehicle. I think it's free with the Texas Department of Transportation. Please do that. That's a easy way of starting your process of your estate planning and passing on your generational wealth. And Nia, it was wonderful seeing you this weekend. And
Absolutely.
I want to thank you again 1,000,000 times over for helping me pass out information. Because after Director Takasha Francis's presentation, my booth just it seemed like everyone came into our table. Nia said, oh. So thank you, Nia, from the bottom of my heart for all your help.
You are very welcome. That's what our partnership is all about, kind of stepping in there where it's needed and making sure we get that information out to the community. So thank y'all very much for participating and coming in and hearing this presentation. Again, I will be emailing a link of this recording out, or if you want to go back and watch on Facebook, that is on AmosHoustonTX.org. For the other person that had needed the questions or had needed the information about the child support and divorce, please send me the email and I'll send you the link for the recording that's actually on our YouTube channel that you can go back and actually watch as well. So yeah, I think that's about it. We hope you guys kind of enjoy this weather that we're having before the heat tries to sneak back up on us, God willing that it does not. You guys take care of yourselves, take care of your neighbors, kind of watch out for one another. We all, again, thank you all for participating and coming back to support a month of service. We greatly appreciate your support. So thank you all very much. You have a wonderful remainder of your afternoon, and we give you the rest of your hour back. All right.
Yay.
We
Thank
will
you,
see you guys next time.